Now, to get back to the free movement of persons. The very important provision that you need to memorize about this is Regulation 492/2011 of the European Union that updates earlier legislation and assists in providing free movement of workers within the EU. It also ensures that the principle of freedom of movement in Article 45 is respected. So Article 45 of the TFEU is the starting point for every problem question that you get on free movement of workers. Free movement of workers shall be secured within the community, and it shall entail the right subject to limitations justified on grounds of public policy, public security, or public health, to accept offers of employment actually made, to move freely within the territory of member states, to stay in a member state for the purposes of employment of nationals of that state laid down by law, regulation, administrative action, to remain in the territory of a member state. So therefore, to sum up, Article 45 gives the freedom to all EU nationals to move from one country to another within the European Union for the purpose of employment, but it is subject to limitations justified on grounds of public policy, public security, and public health. Therefore, EU member states have a right to refuse EU citizens Article 45 right on the grounds of public policy, public security, or public health. Hence, it's not an absolute right. However, the protection of EU nationals, free movement of workers has been strengthened with the introduction of the EU citizenship, which is the concept that was introduced with the new directive, citizenship directive, and that came into force in 2004. Article 20 TFEU, citizenship of the Union is hereby established. Every person holding the nationality of a member state shall be citizen of the Union. Citizenship of the Union shall be additional to and not replace national citizenship. So how do you apply this law to the facts of the problem question? So the starting point is always Article 45. So you need to apply both Article 45 and Article 20 and 21, which is for the citizenship. Article 21, every citizen of the Union shall have the right to move and reside freely within the territory of the member states, subject to the limitation and conditions laid down in the treaties and by the measures adopted to give them effect. Therefore, Article 45 was the initial provision that gave EU nationals free movement within the member states for the purposes of employment, but Article 20 and 21 has strengthened that right and has even increased the rights of the EU nationals to move from one country to another for the purposes of employment. Article 21(2) empowers the European Parliament and the Council to adopt provisions with a view to facilitating the exercise of the right referred to in Article 21. And it further provides the adoption of measures concerning social security and social protection where the treaties do not already provide for the adoption of such measures. Therefore, Article 21 even covers the social security and social protection measures when Article 45 does not mention that. Also, we have discrimination clause, Article 18 TFEU, where it says that the EU national cannot be discriminated on the grounds of nationality. Now, after stating in the problem question that every EU national has a right to move from one country to another, according to Article 45 and Article 20 and 21, you need to move to the definition of a worker. So in order to get this protection, the EU national has to be a worker under Article 45. And the definition of a worker is not set in Article 45. It was set in a case law, in the case law. So you need to refer to the relevant case law to define what is a worker. We have few cases that are important for the purposes of definition of worker. Here, the Hoekstra case, the definition of worker must come from the EU instead of the member states. So it has to be established by the EU. It would be very difficult to accept any definition of worker that comes from national law. If there is a different definition of worker applied to all the cases on workers' rights in the EU, this would create a lot of confusion and disparity. Therefore, to ensure consistency and harmonize the EU law, the CJEU could not accept a national definition of worker, and this was confirmed in the Levin case. Levin case, here the appellant was a British citizen who got married to a non-EU national, and he lived in the Netherlands. The appellant's application for a residence permit was refused. She argued that she had sufficient income for her own and her husband's maintenance. She also argued that she had taken up a part-time employment. So the main issue here was if the appellant here was an EU worker, and therefore if she could get the protection under Article 45. The CJEU held that the applicant's income raised her standard of living. So since she had only part-time employment, was that enough to satisfy Article 45? That was the main issue here. And CJEU said that as long as the income that was received raised her standard of living, that was enough. It was covered by Article 45, and she was a worker. The purpose or motive of the worker is immaterial once the individual is pursuing or wishing to pursue a genuine, effective economic activity. It is enough to get Article 45 protection. Our advice would be to the Levin case also to take into consideration that Levin case also clarified that part-time workers were covered by free movement rights. So there is no threshold as to how much money they have to be earning or how many hours they have to be working. As long as they are pursuing a genuine economic activity, even if it's a part-time job, it would be enough for Article 45 protection. There is another category, which is a job seeker, and it's a different one than a worker. You should have a look at Antonissen case. Seeking a job is different from being employed. Here, Antonissen was a Belgian national who had arrived in the UK, and he was trying to get an employment, but he was not successful with it. He was imprisoned for a drug-related offense, and they wanted to deport him. Following his appeal, the case was referred to the CJEU, where it was argued that only community nationals in possession of confirmation of engagement of employment were entitled to a right of residence. So basically, he was claiming a right of residence under Article 45, but he was not employed. He was only a job seeker. CJEU ruled that the purpose of Article 45 was to ensure the free movement of workers, and that a literal interpretation of its terms would hinder that purpose. Therefore, the court was clear that the status of EU nationals searching for work was not the same as that of an EU national who is actually employed. Member states retain the power to expel a job seeker who does not have prospects of finding work. So the bottom line here is whether or not, in the eyes of the court, the job seeker has any prospect of getting the employment. If the person has been in the country for a long time and there are no reasonable prospects of getting an employment, then the country has power to expel the job seeker after a reasonable period of time without needing to invoke Article 45. Moreover, there may be benefits such as unemployment insurance that cannot be accessed by someone who has never participated in the employment market. What protection is offered to workers under Regulation 492/2011? The free movement of workers involves the guaranteed possibility of workers being able to relocate their families and promote their social advancement while helping the economies of the member state. They cannot be discriminated on the basis of their nationality, and the principle of non-discrimination means that all nationals of the member states have the same priorities in regard to national workers. In other words, they are treated the same way as the national workers, and they cannot be discriminated on the grounds of nationality. For further information, I suggest that you visit our simple study materials on our website for EU law, where we have revision notes, case summaries, essay examples, quizzes, tutorial videos, and flashcards. Therefore, we can help you with the simple study materials that is created by top students and graduates to facilitate your job to get high grades. And if the resources are not enough, I suggest that you get one-to-one tutoring session. That is the best resource we can provide for you to give you some tailored, personalized support to help you get high grades. We have already helped thousands of law students get high grades, as you can see on our reviews. Thank you very much for your attention.